Hi there, friend. My name is John Werner. I used to be a part of the largest cult in the United States. After studying the Bible, Christian history, and ministry, I set my sights on confronting the problematic nature of white evangelicalism in the United States. In 2019, I published my first book as a first step in addressing the subtle issues of this complex system. This podcast will continue that work under the same title. Welcome to The Cult of Christianity. I would really like to stop doing these bonus episodes and have a true break. Alas, the Supreme Court has had other ideas. So, here are the most notable decisions that the cloaked tyrants have made this month. 303 Creative LLC versus Ellenis on June 30th, 2023. The court ruled that the First Amendment prohibits Colorado from forcing a website designer to create expressive designs for same-sex marriages or promoting any civility with which the designer disagrees. Biden versus Nebraska, June 30th, 2023. The court invalidated the Secretary of Education's 2022 program to reduce or eliminate minimal federal student loan debt for borrowers. And the day before, Students for Fair Admissions Incorporated versus Harvard. The court ruled that Harvard's race-conscious admissions policies violates the Equal Protection Clause, which is just such a crazy sentence to say. I'm going to say it one more time, just so y'all can fully take in how crazy this is. Harvard's race-conscious admissions policies violate the Equal Protection Clause, which I guess is the white supremacy protection clause of the 14th Amendment. These decisions have had significant impact on a variety of issues, including affirmative action, student loans, and First Amendment issues. They are likely to be the subject of much debate and discussion in the coming months and years, and we will all get tired of hearing about it. So let's break down what each case means. The one about a website designer who refused to create a website for a same-sex wedding was essentially about the right to refuse service, but the question is, refusal based on what? The designer, Lori Smith, argued that the First Amendment protected her right to refuse to create content that she disagrees with, even if the content was legal. The Supreme Court agreed with Smith, ruling 6-3 that the First Amendment prohibits Colorado from forcing her to create expressive designs that convey messages with which she disagrees. And that framing sounds fair enough, right? Unfortunately, the ruling is likely to have significant impact on the future of anti-discrimination laws in the United States due to the Supreme Court's superseding nature of state laws. And here's the kicker. According to AP News, it was revealed that the request cited in the case was disputed by the person named Stewart, who claimed he never asked for Smith's services. And that revelation raises questions about the basis of the lawsuit entirely and points to the facade of Smith's victory, which is going to be used to set back gay rights. The web designer's lawyer suggested that the request could have been made by a troll, while Colorado's attorney general argues that the entire case was fabricated. But either way, this is the type of situation that is determining laws about discrimination and right to refuse. And you probably guessed it. Lori Smith is a Christian. In Biden versus Nebraska, the Supreme Court ruled 6-3 that the Secretary of Education does not have the authority to forgive student loans under the Higher Education Act. The court found that the Secretary's authority to waive or modify financial assistance programs does not allow the Secretary to rewrite that statute to the extent of canceling $430 billion of student loan principal. The ruling is a setback for President Biden, who proposed to forgive up to $10,000 whoop-de-doo in student loan debt for borrowers. This ruling now seems to favor states' rights, as it affirms that the Secretary of Education cannot unilaterally implement programs that exceed the authority granted by the Secretary of Congress, which is funny because there's already a lot of programs that the Secretary of Education has, but whatever. The ruling is going to impact the future of student loan forgiveness programs in the United States. It's unclear now whether any future president will have the authority to forgive student loans without explicit approval of Congress. And funny enough, the majority, if not the entirety of conservative Christians are against student loan forgiveness. They should probably pick up a Bible. Then there's the case of Students for Fair Admissions Incorporated versus Harvard, which was about Harvard University's use of race as a factor in admission decisions. The case was brought by Students for Fair Admissions, a group that challenged Harvard's admission policies as a violation of the Equal Protection Clause of the 14th Amendment. The Supreme Court ruled 6-3, imagine that, in favor of Students for Fair Admissions, holding that Harvard's use of race as a factor in admission decisions was not narrowly tailored to achieve a compelling government interest. What? The court found that Harvard's admissions policies were too subjective and that they did not adequately consider factors other than race, such as academic achievement and extracurricular activities, which is laughable to say the least. The ruling is a huge setback for affirmative action and will have a significant impact on college admission policies across the country. It's now unclear whether any college or university will be able to use race as a factor in admissions decisions without facing legal challenges. And while that might not sound bad to some on the surface, you have to realize that half of college students are white with affirmative action and used to be around 80% without it. And surely this doesn't have to do with Christianity, right? There's no connections to Christianity for this. This is just politics, right? Well, the Sarah Sky Foundation, which has donated $650,000 to SFFFA, Students for Fair Admissions, that foundation has a long history of donating to conservative causes and think tanks, including the Heritage Foundation. And the Heritage Foundation is a conservative think tank that is affiliated with the Christian right. Also, the 85 Fund, which donated $250,000 to SFFA, is a trust connected to conservative lawyer and Donald Trump ally Leonardo Leo. And Leo is a Catholic and has been involved in conservative Christian organizations for a long time. And so close to $1 million of their support came from Christian or Christian adjacent sources. So how the hell are Christians doing so well all of the sudden with the Supreme Court? Well, one, I'd argue it's not all of the sudden. The Supreme Court's handling of cases involving religion and law in the United States has been suspect for decades. Its decisions have often fallen short of delivering true justice and have instead perpetuated a biased and problematic relationship between law and Christianity. The court's deference to religious beliefs, especially when it comes to issues such as contraception and abortion, have resulted in the denial of essential healthcare services to countless communities, and especially states where Christianity is more of a staple of the culture. The court's composition and appointments have also raised doubts about its ability to remain impartial and unbiased. Political affiliations and ideological leanings of justices have become determining factors in how they determine the law and how they interpret the law, leading to decisions that align more with personal beliefs than with a fair and objective understanding of constitutional principles. This politicization of the court undermines its credibility and compromises its role as an arbiter of justice. The court has repeatedly perpetuated a power dynamic that favors the dominant religious majority. Christian privilege has often gone unchecked, with the court neglecting to challenge discriminatory practices that infringe upon the rights of religious minorities and non-religious people. And this skewed balance between Christianity and other faiths undermines the principle of religious freedom that it claims to invoke. It is evident that the Supreme Court's approach to Christianity has been flawed and problematic. Its decisions have failed to provide equitable solutions and have perpetrated a system that favors the religious majority at the expense of the rights and well-being of individuals from diverse backgrounds. But how did we get here? The Supreme Court, tracing its origins back to the Constitutional Convention of 1787, emerged as a powerful institution responsible for interpreting the Constitution and resolving disputes. However, a critical examination of its early years reveals a mixed legacy. Established in 1789, the Supreme Court's first Chief Justice was John Jay. During its early years, the court reached several significant milestones that shaped its role in American government. One such milestone was the landmark case of Marbury versus Madison in 1803, where the court claimed the power of judicial review to strike down unconstitutional laws. This decision single-handedly strengthened the court's authority and forever changed our governing structure, since now an unelected judiciary had broad powers. Another key case, McCulloch versus Maryland in 1819, upheld the constitutionality of the Bank of the United States, and this ruling asserted federal supremacy over state laws, and also sparked debates about the balance of power between the federal government and the states. Similar to that case, the court's decision in Gibbons versus Ogden in 1824 established federal supremacy in regulating interstate commerce, and that had far-reaching implications, and it fueled ongoing tensions about the proper scope of federal power. Both of those cases contributed to tensions between Southern and Northern culture, which only fueled later rhetoric surrounding the Civil War over slavery. The court's engagement with religion was also notable during this era. It ruled on cases involving the Establishment Clause and Free Exercise Clause of the First Amendment, which addresses the alleged separation of church and state. Through many different cases, the court determined the limits of government involvement in religious matters. While some decisions safeguarded individual rights, others sparked controversy and debate, highlighting the ongoing drama around the intersection of religion and governance. Regardless of political ideologies one has, it is essential to take a critical view of the Supreme Court as an institution. Its power of judicial review, which touted as a check on unconstitutional laws, is in essence undemocratic, as unelected judges can strike down legislation enacted by elected representatives. This gives unfair power to the Supreme Court in shaping policy and thwarting the will of the people. The court's decisions on religious matters have been ludicrous. The interpretation of the Establishment Clause and the Free Exercise Clause has shifted over time, often reflecting what is advantageous in terms of political power. The court has no objectivity and bullies through ideological biases. And Christians in the 20th century realized that they might not always be on the winning side of things unless they started acting. Brown versus Board of Education, 1954, marked a turning point in the fight against racial segregation in public schools. The case challenged the constitutionality of separate but equal policies that permitted racial segregation. The Supreme Court, in a unanimous decision, ruled that racial segregation in public schools violated the Equal Protection Clause of the 14th Amendment. This decision struck a blow to the doctrine of racial segregation and laid groundwork for desegregation efforts across the United States. But not everyone was happy. During the Civil Rights era, white evangelical leaders, often affiliated with conservative Christian denominations, were at the forefront of the opposition to racial integration. They used religious rhetoric and biblical interpretations to justify segregation and promote the preservation of white supremacy. Many of these leaders saw desegregation efforts as a threat to their perceived social and cultural order. And you fast forward almost 20 years later to Roe v. Wade in 1973, which dealt with the contentious issue of abortion rights. The case challenged a Texas law that criminalized abortion, except to save the life of the mother. The Supreme Court, in a landmark decision, held that a woman has a constitutional right to choose to have an abortion under the Due Process Clause of the 14th Amendment. This ruling established a legal framework for abortion rights and the right to privacy in the United States. The issue of abortion often intersects with religious and moral beliefs, including those rooted in Christianity. Opponents of abortion, including many religious groups, argue that it goes against their religious teachings and the belief of the sanctity of life, which is fine. They don't need to have abortions if they don't want to. But is it about the sanctity of life or the sanctity of white supremacy? Because you see, in between the almost 20 years that separated Brown v. Board and Roe v. Wade, anger was festering. There was a rise of white evangelical leaders who opposed racial integration and played influential roles in American politics. Figures like Jerry Falwell and Bob Jones Sr. were prominent white evangelical leaders who openly resisted racial integration and actively engaged in political activities to protect their discriminatory views. Jerry Falwell, the founder of the Moral Majority and a prominent televangelist, rose to fame in the late 1970s and early 80s. Falwell, along with other influential conservative Christian leaders, mobilized a conservative religious voting bloc that strongly opposed racial integration and progressive policies in general. While they were quite careful to never say they wanted to overturn Brown v. Board of Education ruling, I shouldn't say never say, but not say often. Their broader political agenda aimed to roll back the gains of the civil rights movement. Bob Jones University, founded by Bob Jones Sr., gained notoriety for its racially discriminatory policies. Until 1971, the university prohibited interracial dating and denied admission to African American students. This policy became a focal point of controversy and legal battles, culminating in the landmark Supreme Court case of Bob Jones University versus United States, 1983. The court ruled against the university, upholding the federal government's revocation of its tax-exempt status due to racially discriminatory practices. And boy, did that piss off these white evangelical leaders. But these white evangelical leaders wielded significant political influence, particularly in conservative circles, and their efforts were intertwined with broader conservative movements, such as the fight against the re-election of President Jimmy Carter in 1980. Carter himself, a self-professed, born-again Christian, faced opposition from many white evangelical leaders who disagreed with his moderate stances on racial integration and social issues. The connection between white evangelical leaders opposing integration and exerting political influence during and after the era of Brown v. Board of Education is an important historical context to consider when examining the intersections of race, religion, politics, and the Supreme Court of the United States. If you were to only listen to Christians, they would say all that they care about is abortion and protecting babies. But that is not even remotely true. The myth that the religious right emerged solely in response to the Roe v. Wade ruling on abortion is debunked by historical evidence. Evangelicals were largely indifferent to abortion until 1979, when they rallied against it for political reasons. The movement's true origins lie in the defense of racial segregation in private schools. Understanding this history is crucial to comprehending the motivations behind the religious rights rise, and its impact on American politics. The Roe v. Wade decision was used to trigger a significant and sustained response from Christian communities, particularly those aligned with conservative and evangelical beliefs. Christian activism against abortion rights gained momentum as religious leaders and organizations mobilized to protect what they viewed as the sanctity of life. Christian activists organized rallies, protests, and political campaigns to promote pro-life stances and advocate for the appointment of judges who aligned with their views. They formed organizations such as the National Right to Life Committee and the Family Research Council, which remain influential in the pro-life movement today. Prominent legal challenges emerged as part of Christian activism in response to Roe v. Wade. Webster versus Reproductive Health Services in 1989 was a pivotal case that allowed states to impose restrictions on abortions, such as requiring doctors to test for fetal viability after 20 weeks and prohibiting public funds from being used for abortions. While the court upheld certain restrictions, it did not overturn Roe v. Wade outright. Planned Parenthood versus Casey, 1992, marked another significant legal challenge to Roe v. Wade. The case presented an opportunity for the court to reconsider the central holding of Roe. However, the court's ruling reaffirmed the constitutional right to abortion while allowing for certain restrictions such as waiting periods and parental consent requirements. This decision established a standard known as the undue burden test, which remains the guiding principle in evaluating the constitutionality of abortion regulations. And those legal challenges driven by Christian activism reflect ongoing efforts to chip away at the protections afforded by Roe v. Wade without entirely overturning the landmark decision. But as we all know now, they chipped away till there was nothing left. The body and freedom are intricately linked, defining what it means to be a human being, and the overturning of Roe v. Wade last year legally attacked the very essence of identity. And that may sound overdramatic, but granting the state control over a citizen's body erodes their personhood and undermines the alleged principles of America. The fight for reproductive rights is a fight for human rights, and it is crucial to recognize the broader implications of government interference in women's autonomy and all people's autonomy. Because the struggle for bodily autonomy is not just a woman's issue, it is an urgent human rights emergency. To truly embody the supposed American values of liberty and equality, we must include all citizens in the expression of these ideals. The Constitution may not explicitly address bodily autonomy, but it is an inherent requirement for individual freedom. We must confront the reality that denying freedom to some citizens undermines the fabric of all of our freedoms. The body is an essential component of our existence and the basis of our collective and individual freedom. But Christians hate the body. It is both perplexing and disheartening to encounter theological perspectives that downplay or dismiss the importance of the human body. Such views are not only unfounded, but also reflect a fundamental misunderstanding of the human experience. Humans do not automatically subscribe to the notion of a soul or any supernatural entities. They are taught them. Our commonality, in essence, is in recognizing that our existence is rooted in the physical realm, and our bodies are the very vessels through which we navigate the world. The body is not a mere shell or a temporary dwelling for an immaterial existence. It is our essential being, intricately intertwined with our thoughts, emotions, and experiences. To minimize the significance of the body is to deny the richness and complexity of human existence. It is through our bodies that we perceive the world, interact with others, and engage in the myriad experiences that shape our lives. Our bodies are the conduits through which we engage with the physical universe, explore our senses, and derive meaning and pleasure from our surroundings. Focusing on the body does not imply a rejection of intellectual or emotional pursuits. It is not an either or dichotomy. Rather, an appreciation for the body enhances our understanding and appreciation of the human experience as a whole. It compels us to prioritize bodily autonomy, bodily integrity, and the well being of all individuals. In rejecting the idea that the body is insignificant or secondary to spiritual concerns, we must affirm the inherent worth and value of every human being. But that isn't the anti-abortion argument, is it? That our bodies belong to the state. No, the pro-life argument rests on the assertion that abortion is morally reprehensible because it terminates the life of a developing human being. Advocates claim that from the moment of conception, a fetus possesses a unique genetic identity and the potential for future growth. They argue that the right to life is an inherent and indisputable characteristic of all human beings, regardless of their stage of development. Proponents of the pro-life stance often attempt to emphasize the ethical and moral consequences of ending a human life. They contend that the fetus, as a separate living entity, should be protected and respected. They vehemently label abortion as an act of violence, casting it as an infringement upon the rights of the unborn, effectively denying them the opportunity to experience life, realize their potential, and contribute to society. In addition, pro-life advocates emphasize the creation of a culture that places value on life and supports it at all stages. They advocate for alternatives to abortion, such as adoption, and argue for comprehensive support systems for pregnant women. And these alternatives, they claim, offer solutions to unintended pregnancies without resorting to the termination of life. Well, let me be the first to address the misleading nature of the term pro-life. Just kidding, it's been done before. By branding themselves as such, anti-choice advocates clearly position their stance as the sole defenders of life and morality. Such terminology subtly suggests that those of us who support a pregnant person's right to choose are somehow against life itself. But this oversimplification obscures the true essence of the abortion debate. Not to mention that supporting someone else's right to choose does not have to mean you're pro-abortion. There is no stance that says you should always get an abortion. The position is that human beings have the right to make their own choices about their bodies and their lives. One of the critical shortcomings of the pro-life rhetoric is its myopic focus on the fetus while disregarding the well-being, agency, and dignity of the pregnant person. By centering solely on the unborn life, anti-choice advocates dismiss the complex factors that can influence a decision to seek an abortion. Factors such as physical health, mental health, financial circumstances, unstable relationships, or whatever circumstance one might find themselves in. And people who find themselves in those circumstances deserve consideration and privacy. Compelling people to carry unwanted pregnancies has severe physical, emotional, and socioeconomic consequences. Reproductive justice entails providing all people with access to safe and legal abortion so that we can safeguard their health and well-being and reduce maternal mortality rates. It also fosters gender equality, and it is about respecting people's autonomy and recognizing that pregnant people are the ultimate decision makers concerning their reproductive lives. The term pro-life is an artful misnomer that masks the complexity of the abortion debate. So here we are, with a court that can be convinced to align with rhetoric over reasoning, religion over regulations, and power over precedent. Who are these people? John Roberts is the Chief Justice of the United States of the Supreme Court, serving since 2005. Before presiding, he was asked what he would do if the law required a ruling that contradicted his church's teachings. Roberts, a devout Catholic, appeared unsure and suggested that he might have to recuse himself. This unscripted response goes against the principle that a judge's personal religious beliefs should not influence the interpretation of laws. And he did not recuse himself in the overturning of Roe v. Wade. He's sometimes pitched as a humble, conservative moderate, but he is far from it. Chief Justice John Roberts has led a campaign to legalize corruption and equate money with speech in campaign finance cases. His efforts culminated in the FEC versus Ted Cruz for Senate ruling, which allowed big donors to channel funds into politicians' personal bank accounts. This normalized corruption and undermined the integrity of our political system. These campaign finance cases define the legacy of Roberts' court, perpetuating a system where politicians prioritize the interest of wealthy donors over the average American person. And if he's okay with legalizing bribes, my assumption is that he's okay with taking them himself. And next up in the court, we have Clarence Thomas, the Associate Justice of the Supreme Court of the United States. He was appointed to the court in 1991 and has served as a conservative voice on the bench. Thomas is known for his originalist and textualist approach to interpreting the Constitution. But more accurately, he is known as a bad person. In 1991, when Clarence Thomas was nominated by President George H.W. Bush for the Supreme Court, Anita Hill accused Thomas of sexual harassment during Senate hearings, which led to a contentious confirmation process. Hill testified that Thomas repeatedly asked her out socially and engaged in discussions of sexual subjects and advances. She recounted explicit remarks Thomas made about his own sexual prowess and anatomy. Hill also shared an incident where Thomas talked about women having sex with animals, and he would talk about pubic hair in his Coke. I'm not making this up. During the hearings, there were insinuations that Hill had ulterior motives, and Thomas expressed hurt over the allegation, stating that he considered Hill a friend, and he had always supported her. But the truth is, he sexually harassed her, and no one cared. But we don't have to go back to 1991 to prove Thomas is ill-qualified to dictate our laws. A New York Times investigation recently revealed that Supreme Court Justice Clarence Thomas had undisclosed connections and received gifts from wealthy individuals through his involvement with the Horatio Alger Association of Distinguished Americans. Boy, doesn't that just sound like a great group of people. These gifts included vacations, VIP tickets, and invitations to exclusive events, and Thomas failed to disclose many of these gifts and trips despite reporting similar benefits in the past. The investigation also highlighted Thomas's ties to David Sokol, an investor and former executive at Berkshire Hathaway. Thomas declined to respond to detailed questions during this investigation, and these findings add to previous criticisms of Thomas for failing to report luxury trips and a real estate deal. The revelations raise concerns, to say the least, about transparency and his many conflicts of interest. And Clarence Thomas's opportunistic and contradictory path to power raises questions about his integrity. He conveniently embraces Catholicism, though he self-admittedly dismissed it for, about 25 years, alleging that he wanted to be a priest but was not accepted due to his race. Thomas strategically aligns himself with powerful groups and exploits connections for personal gain. And his confirmation process was marred by controversy as his silence and lack of engagement on the court raised concerns initially. Thomas's reliance on originalism and selective interpretation of principles serve as a cover for advancing his conservative agenda. His journey exposes a self-interest pursuit of power. Batting third, we have Samuel A. Alito Jr., who is an Associate Justice of the Supreme Court, and he was nominated by President George W. Bush and confirmed by the Senate in 2006. And guess what? He's Catholic. Alito authored the deciding opinion that overturned Roe v. Wade, and shortly after gave a lecture where he said, quote, "A person's faith shapes what kind of person he is. It should also affect the way you treat people when you're serving as a judge." His anti-abortion views are not the only thing that disqualify him from the oligarchy. ProPublica exposed the Supreme Court justice for his law-breaking and ethical violations by accepting an extravagant fishing trip from right-wing billionaire Paul Singer. The trip, valued at $100,000, included a private jet, luxurious accommodations, and lavish dining. Alito's attempt to downplay the trip in a Wall Street Journal op-ed was a blatant confession of corruption. This is the same justice who heckled President Obama and played the victim when his leaked opinion conveniently served his agenda. So put shortly, Alito sucks. Next up, took long enough, but next we have a woman. Whew, finally. Sonia Sotomayor, who is an Associate Justice of the Supreme Court. She was nominated by President Barack Obama in 2009 and became the first Hispanic and third woman to serve on the nation's highest court. While she is pitched as liberal and concerned with matters of equality, she is not free of corruption herself. She failed to recuse herself from cases involving publishing company Penguin Random House, despite receiving lucrative, millions of dollars, in book deals from the company. Obviously, she's not the only justice to fail recusal when it would be a lawful and ethical thing to do, but 9 wrongs don't make it a right. Oh, and guess what? She's Catholic. In her legal career leading up to the Supreme Court appointment, Judge Sotomayor's approach has been overly cautious, and her rulings on church-state matters often lack boldness. While she does appear to be considerate of religious rights, her decisions tend to favor religious institutions over individuals and prioritize their freedom to discriminate. Though these days, she has been actively calling out her conservative counterparts for dismantling any distinction between church and state, but generally she has ruled more reasonably than the rest of the fools I've mentioned, I guess. Except for this one's a lot more reasonable. Elena Kagan. She was nominated by President Barack Obama in 2010 and confirmed by the Senate. She is not Catholic, but rather Jewish. And I'll go ahead and spoil this for you. All the justices are religious. We got 6 Catholics, 1 Episcopalian Catholic hybrid dude, 1 Jew, and 1 Protestant. Imagine trying to have an atheist on the Supreme Court. Sounds impossible, doesn't it? And isn't that a problem that sounds impossible? Anyways, Kagan seems cool. She has been the boldest voice in calling out her colleagues as corrupt, and she has forgotten decorum in the name of truth, which is great. But unfortunately, she is more than a little outnumbered. Which brings us to Neil M. Gorsuch. He was nominated by President Donald Trump and confirmed by the Senate in 2017. He is unapologetically conservative, a political pawn, and you guessed it, Catholic. Well, sort of. While being raised Catholic, Gorsuch now worships at St. John's Episcopal Church in Boulder, Colorado, a politically liberal-ish congregation. Some hardline conservatives were not happy about this and expressed concern over Gorsuch attending a church that they perceive as pro-gay or pro-Muslim, pro-green, and anti-Trump. The Trump administration then urged religious leaders to push back against these questions and argued that Gorsuch's judicial opinions should be the focus of his scrutiny. Imagine that. Not his pastor's politics. Gorsuch's religious background and affiliations demonstrate shades of gray with influences from Catholicism and the Episcopal Church. But he did his job in fulfilling the conservative agenda and has followed suit with taking bribes and failing to recuse himself. Y'all see the pattern. And then there's Brett Kavanaugh. I really don't even want to talk about him. I mean, he has no judicial temperament or credibility, but he has plenty of allegations of sexual misconduct. During his confirmation hearings, Kavanaugh displayed anger and stupidity. Additionally, the allegations of sexual assault made against him further eroded the public trust and raised questions about his character and integrity. And simply put, he is unfit to serve on the highest judicial body in the United States. And I'm still mad about it, and I'm going to move on to Amy Coney Barrett. Well, dang it. Barrett was nominated by President Donald Trump and confirmed by the Senate in 2020. She sucks. As a devout Catholic, her association with anti-abortion organizations and support for overturning Roe v. Wade is well documented. She doesn't have any judicial independence, given her conservative background and the circumstances of her nomination. Barrett's criticism of the Affordable Care Act, also scary, because being anti-healthcare while being anti-abortion means you're anti-life. Oh boy. Okay, moving on. Last, but in no way, shape, or form least, we have Ketanji Brown Jackson, President Biden's appointment. As a non-denominational Protestant, she stands apart from her Catholic colleagues. While she has emphasized the role of faith in her life and career, she has remained vague about the specifics. Jackson's commitment to her beliefs is evident through her service on the advisory board of a Christian school and her expression of gratitude to God in a 2011 speech. She does seem to be a little more culturally religious than a religious zealot, if you will. Jackson has handled cases involving religious claims such as workplace discrimination and standing for religious liberty claims. She recognizes the significance of the Free Exercise Clause, understanding the evolving nature of religious liberty law, and refrains from expressing personal views on its scope. Jackson acknowledges the Supreme Court's exploration of religious liberty in various contexts and has hinted that there may need to be some changes in how we perceive religious liberty, including in matters such as employment, government funding of religious institutions, and public health regulations impacting religious gatherings. Judge Jackson is probably the best of the nine due to her ability to set aside personal ideology and interpret the law objectively, and it makes her the perfect candidate for the role. So probably the best thing Biden did as president, has done as president. And Jackson's commitment to taking the law seriously ensures that her decisions are grounded in legal principles and precedent rather than personal biases. But one good judge does not a good Supreme Court make. Now, here's the interesting thing. There aren't any evangelicals on the court. Sure, Catholics have been protesting abortion even longer than evangelicals. But how and why is the court supporting evangelical ideology further than on the issue of abortion? It almost seems like a conspiracy. Well, Rob Schneck, former leader of the Faith in Action group, admitted to recruiting and coaching wealthy volunteers, including an influential evangelical couple, to wine, dine, and entertain conservative Supreme Court justices. I'll let that sit for a minute. A leader of a Faith in Action group has admitted to recruiting and coaching wealthy volunteers to wine, dine, and entertain conservative Supreme Court justices. This effort aimed to push conservative positions on abortion, homosexuality, gun restrictions, and other issues without explicitly discussing pending court cases. Schneck, the guy admitting to all this, organized these meetings for about 20 couples with Justices Clarence Thomas, Samuel Alito, and the late Antonin Scalia. The purpose was to create a supportive ecosystem for conservative justices and foster forthrightness in their views. The program, known as Operation Higher Court, executed meticulously conniving interactions between the religious right and the Supreme Court justices during the court's deliberations on social issues. While Thomas and Alito have never commented on these dinners, there is no doubt that outside actors use social activities to influence the court's allegedly sealed environment. Schneck's organization, now known as Faith and Liberty, became part of Liberty Council in 2018, and Schneck mentioned prayer sessions as a means of building rapport with conservative justices. So, just to be very clear, there was a religious right group of evangelical persuasion praying with the Supreme Court, intentionally using those prayer sessions as a way to influence their opinions on social issues while giving them all sorts of luxuries. This isn't conspiracy theory. This is conspiracy. Schneck pointed to Don and Gail Wright, a prominent evangelical couple, as major funders who organize expensive dinners with the justices at prominent DC venues. The Wrights were active in reinforcing conservative views on abortion, homosexuality, and gun rights. Schneck revealed that the couples were coached and provided feedback for their dinners with the justices and their wives. And here's the thing. The religious right is not about agreeing on religion, but rather the politics of power. The term religious right refers to a politically active movement in the United States that combines conservative religious beliefs with political activism. It primarily consists of individuals and organizations who advocate for specific policies, positions based on vague religious values and seek to influence the government and public policy accordingly. The religious right often focuses on issues such as opposition to abortion, opposition to queer rights, and promoting religious culture. Their goal in this movement is not evangelicalism. It's actually an evangelical culture. When any religious group becomes more focused on power and cultural influence than the true essence of their faith, certain patterns start to emerge. Let me know if this sounds familiar. They align closely with a particularly political ideology, seeking to wield influence and gain political clout. Aspects of their traditional viewpoints will be emphasized while others blatantly and conveniently ignored. They encourage a tribalistic mindset, viewing those outside their group as adversaries. Rather than sincerely embracing their faith, religion becomes a tool to achieve personal gain and dominance. It's important to remember that not everyone within the group will exhibit these kind of tendencies, but the cult leaders, the leaders of these groups, encourage these dynamics to the detriment of their followers. A sworn affidavit from the 1990s involving a former member of the religious group People of Praise reveals allegations of coercive control and alleged sexual displays by the group's founder and his wife. People of Praise is a charismatic cult which lists Supreme Court Justice Amy Coney Barrett as a member, and she has refused to make any comment about it. While the Supreme Court is marketed as a revered institution tasked with interpreting and upholding the law, the institution itself employs cult-like characteristics. The lifetime appointments of justices, the insular nature of the institution, the intense ideological divisions, and the influence of group dynamics on decision-making all point to control, contain, and convert tactics. For the past 2 decades, social conservatives, Christian nationalists, and the religious right have strategically voted for Republicans despite disagreements and unfulfilled promises. They understand that the control of the White House and the Senate ultimately shapes the courts. And if they have control of the courts, they can roll back all the progress of an evolving America. Their patience is now paying off as the Supreme Court's conservative majority continues to deliver victories for the religious right, from overturning Roe v. Wade to ending affirmative action and chipping away at LGBTQ equality. Conservative evangelicals' commitment to elections and long-term vision has brought them success, while the rest of us have lost energy in fighting for basic civility. The Supreme Court's recent actions have far-reaching implications, affecting real people and potentially leading to further conservative wins in areas like environmental regulations, women's rights, and even things like interracial marriage. This is bad. We find ourselves confronted with a deeply unsettling reality. The Supreme Court, our nation's highest arbiter of justice, has become entangled in the web of a cult-like influence. If you peel back the layers, you'll discover the intricate connections between Christian leaders, wealthy evangelicals, and the conservative justices who hold almost unlimited power over our laws and our lives. The revelation of Rob Schneck's Operation Higher Court shine a light on the calculated efforts to shape the court's decisions through behind-the-scenes manipulation. It is a chilling reminder that those who have power over us don't care about us. But it goes beyond mere social fabric. The religious right, with its singular focus on power and cultural dominance, has distorted the true essence of faith. Theirs is not a pursuit of religious enlightenment or spiritual growth, but rather a hunger for control and the imposition of their beliefs on others. The genuine tenets of their faith are conveniently discarded when they no longer serve the political agenda. The consequences of this convergence of power and religious fervor are far-reaching. It affects all of us. It affects real people, real rights, and the real ability to live authentically and freely. Queer individuals, people seeking reproductive autonomy, and those marginalized by systemic injustice bear the brunt of these decisions. The Supreme Court, unelected oligarchs now stand as the biggest legal threat to progress and equality. As we grapple with the implications of the Supreme Cult, we must confront the sobering truth that our democratic institutions are anything but. The unchecked power wielded by justices with lifetime appointments, coupled with the insidious influence of well-connected interest groups, proves that it's an illusion that we are any kind of democracy. We cannot afford to turn a blind eye or succumb to apathy. The stakes are too high. We've got to advocate for transparency, accountability, ethical standards. And that likely means abolishing and at the very least radically reforming our court system. It is undeniable that the religious beliefs of the Supreme Court justices play a role in their decision-making. Christianity, in particular, has had profound influence on the court. But even scarier is that Christian brainwashing has created a culture that is complacent at best about this. No one cares that we are in real time becoming a theocracy if we are not there already. Because Christianity has become an unwritten prerequisite for being a part of our government and lawmaking. And behind the veneer of impartiality and the lofty rhetoric of constitutional interpretation, the 9 justices who occupy the highest echelons of American jurisprudence are marionettes, dancing to the tune of an ancient creed. A creed that promises salvation, righteousness, and dominion over the law of the land. All you have to give is your soul. With a conservative majority firmly entrenched, the highest court in the land has become an echo chamber of dogma, a sanctuary where personal beliefs supersede the bedrock principles of justice and equality. There were founding fathers who painstakingly tried to craft a secular framework to shield the nation from the perils of religious tyranny, but those founding fathers lost the war. Unbridled Christian power has found its fertile ground in the hollowed halls, sowing the seeds of prejudice, discrimination, and an alarming erosion of civil liberties. How? How did this cult of Christianity manage to infiltrate the highest court of the land? Well, the answer lies not in the divine, but in the all-too-human machinations of political maneuvering and calculated nominations. Step by insidious step, they built a judicial oligarchy that bows before the altar of Christianity rather than the altar of justice. While the separation of church and state is etched into the very fabric of the American experiment, it appears that the scales have tipped and the Statue of Liberty bows to theocracy. The supreme cult wields its power with a heavy hand, and those who dare to defy its sacred mission are cast aside, labeled as heretics against their divine agenda. Fundamental freedoms hang in the balance, and the notion of a fair and impartial judiciary is dead. And the time has come to confront the cold truth. The United States Supreme Court has become a pawn in the hands of a devoted few. And until the grip of this clandestine cult is broken, the scales of justice will remain unbalanced, and the dream of a true democracy will be nothing more than a faint memory.
If you'd like to learn more about this podcast or other work I'm doing, go to thecultofchristianity.com. If you'd like to support this podcast, listen, follow, share, and consider subscribing for $5 through Spotify for additional content, or give as much or as little as you can to support this work through links in the show's notes. Every dollar helps further this important discussion as well as start other exciting projects. Thanks for listening, and remember to keep love in your life, hope in your heart, and searching in your soul.